Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Emily Pendleton, a Texas construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I would like to introduce the fabulous Emily Pendleton.
Thanks so much, Jessie. Good morning, everyone. So I'll just start with as we go through today's webinar, feel free to drop any questions that you might have in the chat box, and I will try to get to them at the end of the presentation. So starting with big picture key takeaways from today's webinar, I'm going to talk about some things that you can do on the front end early on in order to get paid faster on the back end when things aren't looking so good or a payment problem arises, which is first and foremost negotiating your subcontract agreement. And some key things I'll talk about today are the pay if paid clauses, an interest provision, as well as incorporating your proposal. And then on the back end, if a payment problem does appear to arise, being proactive and sending out your pre-lien notice, or on the public project side for bonded projects, sending your bond notice in order to involve other entities such as the owner, such as the surety, to get them involved to help you get paid. And so these are all things that you can do in order to mitigate your risk and create leverage in order to get you paid faster on construction projects. All right, so starting with negotiation of the subcontract agreement and the pay if paid clauses. So these are very, very standard in Texas subcontract agreements. But if it's at all possible, I always recommend to my subcontractor clients to negotiate out any pay if paid clauses in your contract. So I've put on the slide here an example of a very typical pay if paid clause, which basically says payment to the contractor by owner is a quote unquote condition precedent to subcontractors' right to receive payment and contractors' obligation to make payments to the subcontractor here under this agreement. And then subcontractor acknowledges and agrees that it hereby assumes the risk of non-payment by owner to contractor, right? And so making the subcontractor bear all the risk of the owner's non-payment to the contractor and therefore contractor's non-payment to the subcontractor. And so by negotiating these pay if paid clauses out of your contract, it eliminates the contractor's ability to say, well, sorry, subcontractor, I haven't paid you because the owner has not paid me. And so it is oftentimes difficult to completely negotiate out these pay if paid clauses, but something that you can do in order to come to a middle ground on these issues is to convert it to a pay when paid clause, which essentially just removes the conditional language from the provision. And I'm happy to assist you in any needs arising related to making sure that the differences between pay if paid and when something's conditional, which would typically have this condition precedent language, versus pay when paid, which will not contain that sort of language. And so this will really help you in the long run down the line eliminate payment problems arising from an owner's non-payment and something that you don't have control over. Okay, another thing you can negotiate in your subcontract agreements is to negotiate an interest provision. You are entitled as a subcontractor as well as a general contractor to prompt payment interest under the Texas Prompt Payment Act, which is calculated at 1.5% interest each month on overdue amounts for which the contractor has received payment from the owner. And so You're entitled to that by statute. However, I always recommend to my subcontractor clients to go ahead and incorporate a similar provision with a similar interest rate directly into the subcontract agreement. And this can assist in several ways in, to where there's something that you can specifically point to, a provision in the subcontract agreement. There's no need for the contractor to be aware of Texas law that allows you to this interest. And then also, you can negotiate it such that the interest is not contingent on owner's payment to contractor, but is an outright, interest that's going to accrue once the invoice is overdue. And so having those provisions in there is also going to create leverage when a payment problem arises, knowing that that interest is accruing on those outstanding invoices. Okay, and last on negotiation of the subcontract, something that I see come up and creates payment problems down the road is the proposal, the understanding of the scope of work between the parties, and how to kind of eliminate sort of any ambiguities there. On projects that are bid out and there's a proposal that gets put together, there's a lot of detail and effort putting together what that scope of work is going to look like, and what's being offered, and specifically what's being excluded, and coming to a lump sum or a unit price or whatever it may be in the proposal. And so in this hypothetical where you've got this bid project, the contractor accepts the subcontractor's proposal by essentially just issuing their form subcontract agreement for signature. And these form subcontract agreements, of course, they don't contemplate incorporation of your proposal and set forth their own, standard line items for the scope of work, and don't encapsulate the potential exclusions that you set forth in your proposal as a subcontractor. And so you're going to want to consider whether the scope of work that's detailed in the contractor's subcontract form agreement tracks that of your proposal that you submitted. And to eliminate sort of that risk, you may consider whether or not you want to specifically and expressly incorporate your proposal into the subcontract agreement. And this can eliminate a number of issues that I've seen arise on many different instances. And the primary issue being eliminated is what is the base scope, and what line items are detailed within that base scope, or whether or not this is something that was eliminated or just simply not contemplated as part of the scope of work of the subcontractor, and therefore warranting a change order. And so just making sure that the scope of work is clear within the four corners of your subcontract agreement is going to eliminate those sorts of ambiguities and not have so many issues down the road with whether or not this is added or this was already contemplated at the time of bid, and this is something that should be under the base scope. All right, now flipping over to talking a little bit about engaging the owner or the surety in order to assist you in getting paid. So preserving your right to payment will differ depending on the type of project that you're working on. And so you're going to want to make sure you have a good understanding of whether or not this is a commercial private project, which can be bonded or unbonded, residential private projects, which are typically unbonded, or whether you're performing work on a public project, whether that's state or federal. Those are required by statute to be bonded unless they're under a certain value, which is very, very infrequent. They're most often always bonded. Okay, so talking first on the private unbonded projects and the lien notice. And the deadlines I'm talking about as it relates to this are primarily as it relates to commercial projects and not residential, but the the form notice that I talk about is applicable to both types of projects, commercial and residential. Okay, so like I said, foremost talking about the private construction projects, these pre-lien notices must be sent to the general contractor and to the owner as soon as a payment problem arises. And it alerts, the goal of the pre-lien notice is to alert the owner to a payment problem, and it can assist you in getting paid, right? Because the owner has an interest in keeping its property free and clear of any liens. And so once the owner receives this notice, it's going to trigger a chain of events whereby, the owner is going to ask its contractor, why are the funds that I'm paying you not making it downstream? What's the issue? Because they're going to want to make sure that the lien ultimately does not get filed on their property. And so the owner is required to withhold funds from the general contractor as well. So once they receive the pre-lien notice, for a certain amount, statutorily, they are required to withhold those funds from the general contractor to make sure your claim gets satisfied. Otherwise, they're going to have liability for those amounts. All right, so what does the pre-lien notice look like? It is set out for all projects in which the owner and the general contractor entered into on January 1st of 2022 and thereafter. The Texas Property Code sets forth a form statutory pre-lien notice for unpaid labor and materials. They also have an equivalent pre-lien notice for unpaid retainage as well. And so you can easily combine those notices. This one on the screen is for unpaid labor or materials. And so very straightforward. The language that I have in this warning that's bolded is the specific language needed to be included in order to alert the owner that there could be a lien placed on their property if they fail to withhold future payments to the original contractor to cover this debt, right? And so that's the language that gives them the notice that they need in order to withhold those funds from the contractor to ensure that you get paid. All right, so when you need to send the pre-lien notice, any subcontractor on the project is going to need to send their pre-lien notice by the 15th day of the third month after the labor or materials were provided. And so this is very critical to understand that the 15th day of the third month, this is from the time in which the labor or materials were provided and not from the date of the invoice. And so to the extent that, you're invoicing monthly, but the monthly invoice covers work performed in 2 separate months, you're going to want to look at when was specific work performed, when were materials delivered, those sorts of things in order to determine the appropriate day in which the third month falls in. So specifically looking at a hypothetical, here's a good chart that kind of summarizes the deadlines to send your pre-lien notice to both the owner and to the general contractor throughout each month of the year. But under looking at this from a hypothetical, say you performed work in April, May, and June. You're going to want to look at when is my lien notice deadline if I have work performed in those 3 months, but I haven't gotten paid. Well, so the earliest time in which you performed unpaid work was April. And so you're going to want to make sure that you send your pre-lien notice no later than July 15th in order to make sure that you perfect and preserve your right to payment for that work performed in April. And of course, that July 15th notice should also encapsulate the unpaid amounts of work performed in May and June as well. So you're not leaving anything on the table. You're alerting them to the full amount that's outstanding and due. And you'll just preserve your rights to all outstanding amounts. That doesn't mean that you have to stop performing work or anything like that. You'll just need to be cognizant of, as time goes on, if there's July amounts that are become due, August amounts become due, you'll need to send an updated notice in order to make sure you preserve your lien rights, notice to the owner and to the general contractor. These outstanding amounts are due. Okay, and one final note on the pre-lien notice. So these are just the things that you need to make sure you do. And ideally, this notice gets you paid and the owner doesn't want the lien ultimately filed on the property. However, be aware that after you have a deadline in order to file your lien affidavit. And so if you continue to perform work in July and August, you'll want to send an additional pre-lien notice of those amounts and then file your lien affidavit, which needs to be filed within the 15th day of the 4th month after you complete your work. And so, in my hypothetical, if you complete your work in August, you'd be looking to make sure that you get your lien on file no later than it would be December 15th. And these are also just deadlines. There is no harm in doing anything early, and then releasing those lien rights once you've gotten paid. Okay, and so now flipping over to the bond notice. On bonded private projects, you're going to be looking at the same timing requirements, notice requirements as we just discussed as it relates to the lien. But you're going to want to be sending your notices to the surety in addition to the owner and to the general contractor on the private side. On the public side, for public construction projects, these need to be sent, the bond notices need to be sent to the general contractor and to the surety, alerting the surety to a payment problem, which can, assist you in getting paid in the same way as the pre-lien notice. The surety will investigate the payment problem and has an interest in ensuring that the contractor satisfies its debt. It's also going to protect you in the event of the contractor's insolvency on the project, making sure that the surety is there to back financially the project and the subcontractor payments. Okay, so on the bond side, there is no form like there was for the pre-lien notice. However, you need to encapsulate pretty much all of the same types of information that's required under the pre-lien notice. And in addition, you have to include a sworn statement of account that includes the amount claimed is just and correct, and all just and lawful offsets, payments, and credits known to the affiant have been allowed. And those are really just like quotes that you should include within your sworn statement. And since it is a sworn statement, you want to make sure that it is notarized, signed and notarized, before submitting it to the surety. And if there is outstanding contractual retainage, you'll want to include that in your notice as well. Okay, so on the bond side for public projects, the deadline for a first-tier subcontractor is the same deadline we talked about as it relates to the pre-lien notice. It's going to be the 15th day of the 3rd month after the labor materials were provided. Again, not from the invoice date, from the date the work was performed. But for second tier or lower tiered subcontractors, you're going to need to send your bond notice to the surety and to the general contractor by the 15th day of the 2nd month after the labor or materials were provided. So this is a pretty short turnaround time, and needs to be, known for second tier or lower subcontractors. There's not a ton of time in between potentially when your invoice becomes due and the date upon which you need to be sending your bond notice. Okay, and so with that, I conclude with the three things I've talked about today in order to ensure that you get paid faster. Negotiate your subcontract agreement from the outset and make sure that that's got all the provisions in there to ensure that you get paid quickly and timely. And then on the back end, if a payment problem seems to arise, make sure you send your pre-lien notice timely, make sure you send your bond notice timely, in order to create that leverage and involve other entities that might have liability if the contractor does not pay you. And with that, I turn it back over to Jesse.
Hi, thank you so much, Emily. That was amazing. You gave us a lot of really good insight and knowledge to kind of take back and make sure that we are protected in our contracts and so forth. For questions, I don't see any questions at this time. However, if anybody does have or does think of a question, please feel free to reach out to myself or Emily, and we will be sure to answer any questions for you. You go ahead and switch to the next slide. Thank you. Please go ahead and take a moment to review us on Google. We would really appreciate it. It helps to make sure that our webinars are getting out there to more contractors and seen. And with that, that is all we have for you guys today. Thank you so much again to Emily. Thank you everybody who attended. We hope to see you guys at our next webinar, and I hope you have a wonderful sunny day.